Today, I'm excited to welcome Ms. Vrinda. She's with me here at Shweta Stockies, 15 years as a lawyer, mostly with civil cases. You will be very happy to know she can handle massive consumer right issues as well as real estate issues. She is answering a few questions which all of us have. So, Vrinda, explain to us, or for the normal audience, all about consumer laws in India, the whole landscape. How does one approach issues as a consumer? How does one solve their problems? Where do they go? Just give us a little bit of a sight map.
Right. So, Shweta, in fact, if you talk about landscape, it is something which is, in fact, so wide, so impactful to begin with, firstly, because, generally people don't know what their powers are. Why I say people is because consumers are like laymen. It's like us, consuming anything, utilizing anything. So, who is a consumer? You go buy something in the market, you're a consumer. You buy a ticket, you're a consumer. You sit in a train or an airplane, you're a consumer. Anything, buy a home today, you're a consumer.
What are the bodies that work around it?
Right.
What are they?
In fact, there are two branches of it. It's goods and services, which in fact kind of divides the categories of. So goods would be just buying a product, whereas services would be, like I said, banking, aviation, travel, for example. Now, there is also some portals like Amazon, Flipkart, which are doing goods and services both. Right. So it is just not the service they're providing. They're also sending you the product.
Okay. And how do you technically is it a consumer act?
Yes, all of this would be under the Consumer Act. Any buying or selling.
Okay. And how do you define it?
So, in fact, it's a very relevant question. You've just asked about the commercial, there are commercial transactions which happen. Like today, if I'm buying, for example, I'm purchasing a house and if I'm buying it for utilization. Now, let me tell you, utilization doesn't mean I have to live there. I could also use it as my office. But the utilization of that office is for me, right? I am gaining whatever I have to gain. I haven't given to anybody else to use. So when I give the product or the house or anything that I buy to someone else for use, I will make a profit out of it.
Okay.
Right? So I do not fall under a consumer law. So for example, if I buy a house and I resell it, it won't be under consumer law.
If I rent it?
Again, it won't be.
Oh, I didn't know that.
Right. So we have to, when we're using something for us, then you're a consumer. Otherwise, you'll be any other commercial, somebody utilizing, it's a commercial transaction.
Vrinda, tell us about some cases which have been a landmark in your own career, which also have a lot of learning, especially when it comes to real estate.
So this matter came to me through a friend. This is a very landmark case, and that really changed the perspective and the whole understanding of consumer law pertaining to home buyers. Little did I know that like I said in the beginning, that it has so many provisions and such impactful provisions which we don't know. I mean, it was literally, it became a nationwide news. Is why? Because apex court, consumer court, see, this is an additional court to civil courts. These are not those courts wherein it's like a high court or a supreme court, which everybody knows is massively empowered. Consumer court is an additional court. It is like a tribunal. So it became a massive news is because this was the first time in the history of consumer courts where the consumer court sentenced a chairman of such a big group for 3 years imprisonment. And that was under section 27 of the act, and we just invoked the penalties. So normally what happens is that when you have a home buyer dispute, you are going to seek compensation for your delayed possession and you will either ask for a refund. When they don't, there's a decree passed, decrees or judgment, when the judgment is passed and they still don't honor it, you go for execution. That's when, I'm sorry to say, but when it comes to home buyers, you have to catch their neck in execution. That was our learning. And when we did that, we invoked the penalties on them.
For example?
For example, was attachment of properties, which is very generic. That happens. Okay. But again, attachment takes time. You're going to attach the properties and then you're going to sell them and then the home buyer gets its refund. But I thought that the faster way was when there is a sword of imprisonment. And when we, time and again, was addressing the court, we realized that the managing director and the chairman, they are the ones who stop the repayments, though despite there is a judgment already in place. Please
I
understand.
see, I see.
Like you're supposed to give me this in 4 weeks or 6 weeks, but they don't budge. These big developers will still not give you your refund. So what do? It's again a limbo. You'll go back again to the court. So that's the time you have to invoke the right provision, which a
Okay.
lot of consumers and lot of even, I'm sorry to say, a lot of lawyers who regularly, I mean, we see that every day, don't know.
So help me, let's make it crisp for someone who's literally watching it for 2 minutes. If I have not received my possession, step 1, 2, 3 to make sure that I'm secured.
Yes, a very important aspect. Firstly, whenever you're finding, see, you are going to obviously once you come into a relationship with the developer, you will see some red flags, and they are going to be like there is obviously a payment plan in question, and they are not developing as per the payment plan. That's your first red flag.
The construction link plan.
The construction,
mostly
link plan.
yeah.
Absolutely. So that's your first red flag that, oh my God, they are not going as per that. So I know my money may not be being utilized for the purpose I'm giving. Please start preparing a correspondence from that very moment. The first thing is all your paperwork is going to come handy. Because, under law, you have to act in time. And there is a 2 years limitation.
I see.
You see, if you do not, from the point of refusal, that, okay, I'm sorry, we cannot return your money and we are still taking indefinite amount of time and there's no explanation. You have to approach the court within 2 years from the refusal.
From the refusal?
From the refusal.
Not from the date of allotment papers?
No, not from
Okay.
the date of allotment.
Okay.
papers. So that starts
And that
from-
refusal has to be recorded?
It has to be recorded.
Okay.
So it has to be penned down. It has to be on emails. Even WhatsApp today is admissible. But you need to create that correspondence and within the 2-year timeline approach the court.
So what typically happens that mostly, let's say if I didn't get my payment, I'm thinking, should I call the cops first? Should I call the lawyer first? But there has to be certain first few steps, documentation wise,
Right.
that I must take care of, besides having a trail of evidence that I've not been paid for and the conversation. What are those?
Right. So the first and the foremost thing is whenever you're dealing with a home buyer, firstly go through all the brochures that they're providing you. And of course, as laymen, we can't understand. We are going to sign on to those agreements and we will enter into the relationship. From the very first day, please keep a copy of all the documents they're giving you. From the brochure, the signed agreements, the demand letters which come, which are your payment schedule. Like
Interesting. I didn't think brochure would be such a big thing.
it's very important because the brochure defines your provisions. Today,
And also what they probably want to or promise to deliver.
absolutely. See, the thing is that your dispute may come after 5 years or 3 years. Today, the brochure I've given you can change in 3 years.
I see.
So I need the proof from the very first day that where is the brochure that you're selling me? So the brochure, the demand letters, the receipts of payments, again your paper trail, like I said, the correspondences, specifications are very important. They are part of the brochures, the amenities. There are amenities within the society where you're taking the flat, and there are some specifications of the flat. So, it's like all of this is in the brochure. It's very important.
Wonderful.
And you have to also do a credit check. You need to see about the developer, see he has all sanctions. So when I said that you please do a background check on the developer, the first thing would be, are you RERA compliant? So these
Even
are
the broker
certain.
has to have a RERA number now.
Absolutely.
Let's say if I've bought an ad, the delivery according to RERA is 2029, which they try not to mess up now. But still the internal amenities or the fittings or the fixtures are not per the brochure or what the selling agent or the salesman has promised me. What can I claim?
Yes, you can claim your complete compensation. The firstly basis.
Payment so far?
Yes.
Oh.
Absolutely. So it is out there. I mean, you need to, of course, if you see, what happens is, like in my personal cases, which we've gone through, when your flat is not as per the specifications, then people generally put their own things, like the fittings, and you'll get it done that, okay, I need to take possession, and under protest, you can do it, that I'm completing it under protest, or I am putting all these things with my own money. So all those bills, please keep handy. All of it can be refunded and will be, because this is an unfair trade practice.
I see. Is that what it comes under?
Yes. So this is an unfair trade practice. You've promised something and you've not delivered that.
Lovely.
So just not the compensation, and also the refund of all that you've spent. Compensation is above that. It's all your mental agony, harassment, everything is covered.
So, Vrinda, what are the common red flags one must look for while signing or reviewing real estate agreement?
Yeah, there are a couple of things which are
Residential
obviously,
in this case, yeah.
yeah, like very necessary in terms of when you're buying, purchasing a house. That is, the first part of the agreement will obviously have the details as to the sanctions of the land. So that's a very important aspect. Like, are you RERA compliant, the developer? That has to be mentioned. There is a RERA number given. You must see that. And even on the RERA website, you must check that is it correct? Because see, you can sell anything, but you may not be. So this is very important. Secondly, is that where the land is, the plots are cut out. That authority, like in Noida, it would be YEDA, which is Yamuna Expressway, or in Haryana, it's separate, or it's DDA here in Delhi. So all I'm trying to say is that these are separate. The sanctions which are given by these land allotting agencies, again, that have to be mentioned in the agreement. Please check through RTI if you can.
I see.
So
right to information.
Yes.
Okay.
There's no harm. See, it's a life saving you're putting in. So even if you have to wait for 2-3 months to get a response, why not? Right. And the agreement needs to have a very important aspect is the OC. So of course, if it's a construction linked plan, always should mention is if it's not a construction linked plan, which means the houses are ready. So to take the possession of the flat that you're buying, you need to have a completion certificate or an occupation certificate. Otherwise, if you do not have the completion certificate that the developer has and he cannot give it to you, tomorrow you cannot sell the property. So that's the biggest red flag. So it's very important to check that.
So I have a question. So the builder said something or mentioned or disclosed something about the OC. I did not cross check it. I went and put my money in. I went and bought it also. I am also unaware, which likely that these days they won't be.
Very true.
Now he obviously was not compliant. Me myself have not really helped even check out the compliant. Where do I stand now? I can't claim anything after that? Or there is still a recourse?
Yes, Shweta, this is exactly where consumer law is going to help you. This is
see.
exactly what it is. See, I've consumed something. I did not know in first place it was deficient or not. Was it as per what was promised, what was assured? So you are here under two major disputes or two major flaws, which is unfair trade and deficiency in services. And unfair trade practice and deficiency in services further can categorize that, okay, you were cheated by giving you by an unfair contract or by a misleading advertisement, or it was not as per specifications, it was expired, or it was like I'm talking about a product, or if it's a home, it was not as per the specifications given. That's the recourse available. So consumer law is exactly that time that you need to completely go and invoke. And for that, like I said, that one has to be slightly vigilant about keeping all the paperwork.
Correct.
And you need to start with a legal notice, and and the beauty about consumer law is you don't even need a lawyer.
Oh, you don't need a lawyer?
Yes. Yes, a lot of people actually go and fight their cases themselves. But I do understand that when it gets a little technical over the period, it's not I'm advising that you shouldn't have a lawyer, but if you can't afford one, it is for, again, like, it's for common people.
And so RTI would be the first place to go to?
Yes. RTI would be the
That
first
would
in case of
guide you.
Yeah, in case of the sanctions and other things you need to know about the land.
Okay. Delay in possession, how does one navigate that typically for real estate?
So delay in possession is again one of the most important disputes. Mostly the home disputes today that you see in any of the consumer courts is about delayed possession. They give you in the contract promising you 2 years, 24 months, 36 months. It's generic. So always again see one more thing, that if it's the timeline given, there is also a redressal given in the agreement, which I missed out earlier to tell you that there is an arbitration clause, which again can be your immediate remedy. You don't even have to go to the court.
For that we need to go to the lawyer.
Arbitrator. So there are arbitrators which are institutionalized arbitrators. What I'm trying to say is that in the agreement itself defines.
I see.
So if that is there, then you don't even need to approach the court. You can quickly do that. But for obviously delayed possession, you'll have to approach the court and take your compensation.
There have been changes to the consumer law in India.
Oh yes.
Tell us a bit about it and specifically what sounds a bit exciting to you.
Yes, so like I've been mentioning since the beginning about this unfair contract and misleading ads. They were not there earlier.
Oh, I see.
They weren't. So, I mean, how do you prove that, listen, I've signed this contract? And when you've signed it, you're supposed to know what you've signed. But as laymen, like you said, we are all signing, we don't know what we are signing. So we are signing, we call it signing on dotted lines. Half the time the forms are not even filled in. Right. Or for example, if there is a, let's say, delayed possession, but I'm going to only give you 2% interest.
Okay.
So, I mean, when you go to the court, you're asking me 18% on delayed payment. You're giving me 2% compensation
on not delivering.
On not delivering. So the court can change that. That's unfair contract.
But this was not there before.
This was not there before.
So what was happening before?
So 1986 Act was there earlier with just about 35 sections. Now there are, in 2019, the new act has come, which in fact just got, it came into power in June 2020. And today we have about 107 sections.
Oh, wow. Okay.
So it's a massive, change in the consumer law. It's become so handy in terms of like these additional aspects which have come, which I just said about that you can approach the court yourself. And there's a timeline for even deciding cases, which wasn't there earlier. Now it's become time bound.
So I hear. Even earlier this morning, I heard with the shoot.
It's all time bound now. So it's not like earlier people would just be running pillar to post and not getting the relief.
On the new consumer laws, give us an example, a live example or a very recent example of how the changes have now impact what happens in a case or
right. So like I said, the ambit has really expanded, like of the new laws, beginning with, how we've, this misleading ads, of course, have been added, where you're being shown something, but the product is something else. So for example, this was not earlier there. It was only earlier. The difference was that we were just bound by the agreement and the brochure. Now you can also show how you were pitched. Right.
Oh,
so yes, everything is admissible. What you're showing on your billboards or even on YouTube, and
so like a salesman pitching you can be admissed.
Absolutely. So misleading, for example, then unfair contract, again, for example, again, you've been asked, you've been sold something with, like a compensation amount, which is different from what you are being charged in the entire contract. So this is very unreasonable on consumer that I am supposed to pay a delay payment of delayed interest of 18%, but what compensation I get is negligible. So that is again an unfair contract. So it is only after the signing. And then after sales is a very, very good example of how things have changed under the consumer law. Today, after sales services like AMCs, we quickly buy, by buying a phone or we are buying some electronic, and we usually sign those little, AMCs, and we forget about it. And even as a consumer, you don't know how much power that little piece of paper has that you've paid, 1,000 rupees or 2,000, 3,000 that you've paid over the year.
Medical negligence by the doctors. That seems like a big one. How does this happen now?
Right. So again, this is a newer
earlier
feature.
Versus later.
Yeah.
Okay.
This is also a newer feature. Not that earlier there used to be no medical negligence. Negligence itself, medical negligence was taken separately. So all these laws which we are discussing today, consumer being an additional law, there are parallel courts as well. You have a civil court, which anyway is there, which is your district, high and Supreme Court. But there are parallel courts, like if you're going to for a home buyer, a parallel court would be RERA, right? A RERA tribunal. Similarly, for medical negligence, there's a medical negligence tribunal. You can approach the courts that this negligence happened. But consumer also deals with it because you are a consumer as a patient. You've consumed the service. You've gone to the hospital. You were advised this. Like today, a lot of people go through this that, listen, I didn't even have this issue, but I had to go through so many tests. And ultimately, they diagnose something else, and I got something else. Like after the treatment happens, you realize that you were treated for something else. And when you go to another doctor, you find the entire thing is scammed. So you can approach the court.
But it remains a civil offense.
It's a civil offense.
It's a civil offense.
It's a civil offense.
And so you're saying if I take that route, I am not 8 years within the court system, but you say that has now been changed to a 90 days. Is that what you're saying?
Yes. No, not really 90 days, Shweta. 6 months is minimum because you file a complaint. That's the process the consumer court will follow. The first thing will be a complaint with all your documents. that you're filing, which like I said, that, your agreements and your demand letters, your receipts, your correspondences, affidavits are all part of that complaint.
So you take the doctor to court, or you take the hospital to court, or you take both to court?
Depends.
Oh.
Now, if it's a private clinic, there's a doctor. There are a lot of cases like, how these people, for example, skin specialists and the hair transplants today, they are selling you something.
Cosmetologists, yes.
Yeah, so I'm just not talking about, like the bigger treatments which are happening, which is slightly, again, very hard to find. But I'm talking about cosmetic surgeries today, the way they are being sold. They tell you this is what is going to happen to you, but when you come out, you're like, what did just happen to me? I mean,
What is the cosmetology is governed by who? What does it come under? Because I think it's still there. It's just growing. Do you take it to the medical courts? What is that?
So that would come under consumer. Yes, because now, again, depends upon that whether that person is a doctor, a registered doctor or not. So you need to do your due diligence. We can't completely come out of it. But there is, you've consumed, you've taken a treatment, and you very well come under consumer law.
Vrinda, we've discussed real estate so far. What about financial and banking services? And let me know with an example so that we understand exactly what we're looking at.
Yeah, Shweta, I have a very interesting example now when you've talked about banking. I mean, it was an eye-opener for me too when the matter came in. There was a client who actually came weeping, and she lost all her savings in a bank locker. So, and
like a physical vault.
Yeah, like exactly, a locker. And it's a very esteemed bank. It's a very massive chain. And for the first 10 minutes, I was trying to get her control of her. And I just realized that it also kind of was mind boggling that, you lose everything that you've put in a bank locker. There's jewelry, there's money, there are your
Documents.
house papers, and it all went. And she asked me, what am I supposed to do? Help, whatever. I mean, she went to the, how it is, all of us would run to the police. Now, obviously, these are all bigger names. Nobody would do anything. So then I said that, the remedy that you have is consumer. You have consumed a banking service. And we had we approached the courts. We got a very good landmark judgment, which is, in fact, has placed this beautifully. That's Amitabh Dasgupta. That judgment has come in 2021. And that judgment squarely talks about that banks cannot wash away their liability.
I see.
Just because there is, in this case, there was a seepage treatment. Now, that's not force majeure. That is not something that has happened unforeseen.
Correct.
Right? So just to say that, listen, I don't know what is there in your bank. I'm not responsible. I wrote a letter to you. In today's time, there is just not hard letters sent, like a letter sent.
How did she lose this exactly?
So it was, they just wrote a letter to her saying that we'll be doing a seepage treatment.
Ouch.
And you're supposed to come and clear your locker. Now, during that time, they sent a physical letter on the last known address. It did not reach to her. And they very well have your email IDs. They have your phone numbers because they are sending you emails. You have all your emails coming every day from the banks. And there's just not one account she had. She had a current account, savings account, and a locker there.
I see.
Right. So I said they're supposed to. So very important aspect is the communication. So the communication has to reach. And even if it was a seepage treatment, the seepage treatment is not something that happens regularly in the vault areas. These are strong built areas. So that means it was a defected section.
Oh, so that was your argument?
Yes. That's a defected section. That is because of you. You did not have a well-planned vault area. Vault area is made out of strong pillars. It cannot have dampness.
Oh, understood. On from banking, what about things like educational courses, services? We buy curriculums, they are online, some are offline. You can still probably go and debate that, okay, the physical assets are not the best, but what about online? What if I've signed up for a course which I think is going to deliver some semblance of credibility to me, but I didn't like the content and I thought I could have done without it. What is my recourse?
Yeah, so there are massive, again, there's a law fully laid down to that aspect that if, again, education is a service. Obviously, all these things, Shweta, has to be backed with a good amount of concrete evidence.
Understood.
Right.
Understood.
But there is, again, a landmark judgment, Dalbir Singh, which has outlined this beautifully. The whole money of the student was totally refunded because the promising and the promises and assurances given were not kept in the entire cost structure. but they backed it from finding out from the other institutes and how the teachers were not coming, they were not there to hold classes, there were not proper system in place, the infrastructure not in place, what
Did
they
they
had
question all that?
promised, all of that was not in place, and it was a landmark judgment. The entire fee with compensation, with mental harassment, everything is accounted for and is given.
In such cases, give me one example. How do you understand or preempt the kind of compensation you're liable to have? How is it calculated? I am not talking about one particular. In general, what's the math? Real estate is fairly quite there.
Right.
But in something like this, education, I mean, are they refunding my course, or can I ask for additional damages? Or
Right.
waste of my time, or
No, I totally understand. And that's again, the courts mostly are figuring that out. Firstly, the compensation is only to be given where there is a loss.
of time?
Loss of time, loss of profit. That aspect has to be seen.
Okay, so how does one calculate the loss of time? Is it like a math there? Is there a formula there?
Yes, absolutely. Like,
There is
let's
a
say, for
formula there.
example, it's a formula in the sense that you will, again, you'll have to back it up with evidence stating that, listen, if I was doing this during this time, this is the amount I would have earned. And you have to substantiate with getting all those things before the court. So whether, for example, there was a very, so people again ask for, let's say, a huge amount, and the courts below, they even kind of grant you. But in a case, it was reduced, the compensation was reduced also.
I
Because
see.
you haven't backed with the concrete evidence. You have to show, you have to do that due diligence that someone else in this place is earning this much or would have got this much.
But Vrinda, it becomes extremely daunting for a
It is.
student. Let's say I'm trying to prepare for my MBA, 150 ads out there, misleading, not misleading. I at one point did distance MBA because I was in a full-time job, but it was really hard. So you kind of tend to land on the top 5 or top 3 or top 10, however you go for it. But for the normal person who will be unable to pull off those kind of fees and are relying solely on the kind of ads which are out there, or the kind of conversation we have, the curriculum course guiders or whoever, can we take them to court if things are not delivered back? As a student, I have not gotten any benefit.
You can absolutely take anybody to the court who's given you false assurances, provided you have the right evidence. Everything has to be nailed.
Implicit.
Yes.
So my conversations with that guy would be
Absolutely.
in evidence. The ads, they'll
Absolutely.
be evidence.
Absolutely. The law is very clear on it.
That
And
also means I might have to record the conversation.
loud as people are, but then I think anything that is promised is at least taken on an email. Least to
see.
say.
Okay.
Least to say. All the transactions need to happen over there or through at least a WhatsApp, something in written. So more than the oral or the verbal evidence, the written evidence is admissible.
And now WhatsApp.
WhatsApp also is
absolutely
admissible.
legit for
yes, it's legit.
We were talking about more on the domestic front now. Marriages, divorces, compensations. I know it might be like more like a divorce law function, but where does the consumer rights kick in such cases, filing for divorce, compensation? Does it? Yes, no.
No, that will, Shweta, be a completely different leg. Consumer is your civil, so is also divorce. But consumers, again, absolutely and only into consuming, utilizing a product and service, and after sales and other aspects.
What if
which
the
are
man
covered.
didn't deliver his services asking?
That's a very interesting way.
I mean, the woman didn't deliver her service, there should be.
Won't come under consumer, but you definitely have your family courts to go to.
We were talking about domestic violence in this case.
Yes.
And let's say I'm in a household which is mine, I bought it, I am married, we got into a fight, he broke everything. Where do I go? Can I take the loss back for that?
You mean under consumer? No. But yes, you can surely take the loss of all that you have gone through in terms of the harassment
Fair enough.
and the violence.
So, Vrinda, this whole gamut of consumer law, which was pretty new to me, and when I sat with you, I thought we must get it to the audience. Is it really effective, or is it more like more like utopia? May happen, may not happen, and is it happening? Tell us a bit of the foreground, and now what's happening.
Right. So consumer law, Shweta, it is very effective. And see, I'll tell you why. This is a branch, these kind of tribunals, like consumer, or you have other tribunals which are like that, are specifically formed for this purpose. It is like where a consumer can go and talk and actually put up the grievance out there. and you don't have to go through the whole hustle of approaching the bigger courts and those time consuming and very, very overwhelming processes. This is very simple. One complaint out there with your documents, there you are. And like I said, a consumer can himself or herself do this. So it's very impactful. Now, the newer law, like I said, it's all time bound. You have 6 months to 1 year to decide the complaint. Everything is in limitation. 15 days time to file your replies, 15 days time to file your evidence. So you
Oh, I
cannot run
see.
away. Yeah.
So now, if the personnel in the consumer law ecosystem himself is delayed, now what?
Right. So that's where the catch is. You've got to be within 2 years. But
So they are mandated to solve this in 2 years?
no, sorry. So I mean, if a consumer is late in terms of approaching the court after 2 years, you have to get, there is a term called condoning your delay, the condonation of delay. You'll have to file explaining the court the reasons and legit reasons. And there are judgments today to that aspect as well, like the Shivraj judge, and there are various other judgments like that, which says that if you have, courts have to go pragmatic. They have to go less technical, and they find that
We hope.
okay,
We
yeah,
hope.
yeah.
Are we manpowered enough to service a massive country like India? And that kind, it's a yes or no question.
No, not yet.
And do you think we're working towards it?
We are very far from it. But I will obviously say that how, our recent, even, like how our recent chief justices have come and how things are changing. We are looking
We are
at a
working
brighter.
towards it.
Yes, we are.
Definitely
We are.
working
We are.
towards it.
We are.
One can
Like Bombay right now just had their double, the judges, the number of judges have increased to double.
Yes, I hear.
Yeah, so that is again a very big thing, and it's happened overnight. So there are things coming in place, but yeah, we are really far from there. We have a massive population to take care of.
So, Vrinda, thank you for this because I had no idea about the amount of rights me as a normal citizen have in purchase of sales, goods and services and assets. However, I mean, yes, there are reforms, I understand, but example, in cases of large insolvencies, bankruptcy declare करने के बाद तो फिर कुछ फायदा तो हुआ नहीं ना.
Right.
In that aspect, what irks you? What would you wish happened better? And what have you witnessed?
No, this is absolutely something which I'm struggling for a very long time. Yes, I feel good about one thing, that I could get a lot of refunds back, and a lot of home buyers got that relief. But I have seen people really crying, when they come to me. Their life savings are gone. They are in a limbo. They don't know when the refunds will happen. Very big groups like Jaypee, Unitech. I mean, there are hundreds, thousands of home buyers waiting in lurch just to get their refund. Now, the fact is that today, what happens? I'm happy about this, that insolvency does not take away, a general recourse would be that the developer's assets go and
Get attached and
they get
liquidate
attached
or
and they
whatever.
sell off and they give you the money. And but now the course is that the government takes over, and like for example in Supertech now you have NBCC, and they are coming up. They're taking over these projects, finishing them, and giving it back to you. But nothing in the courts move. You see, moratorium comes into place. My cases are at a halt. Now there are people who have already got their judgments. That's the area. If I'm able to explain, when you get your orders and you're in your execution, final execution, why do I stop after fighting for 3, 4, 5 years just because of a moratorium? And I will not get my refund because the decree is already adjudicated. It's already decided. My rights are decided. I am decided that A has to get this much money. But because of that one moratorium order, it all goes.
It's a sad
limbo.
aspect. And if I'm looking at, you see, it's actually, I don't know, correct me if I'm wrong, criminal cases are somewhere maybe quicker because civil cases can go on.
They can go on
forever.
and on. Absolutely.
Has it become any cheaper to fight these? As we get more laws and provisions to fight it, I mean, there are more ways of approaching my right. Is it still massively expensive and time consuming? I have understood that you have said those things have been corrected. I'm talking about the financial drain of it.
No, absolutely.
normal
I'm
person.
I'll be very honest about it. As far as the court fees is concerned, if you're talking about the court fees, it's very minimal. But that's not what it is. Now, today, if people are getting their reliefs, obviously you have to approach the lawyers. You need to get the right person. and that works. Today, if I say that, Shweta, you can do it yourself. After a while,
नहीं
okay,
कर
probably
पाऊंगी.
initially आप complaint file कर दोगे, but that's it. But that's not correct. You have to spend that money. And all those cases wherein I have seen results coming, there have been two things. There have been massive amount of help from the litigant. Litigant, I mean, is the complainant, the consumer himself, the work that they have done from the beginning, like I said, to the T, that everything is right there. The paperwork is ready, and you need to spend that money.
Yeah, it's substantial.
It's I'll be honest about it, because there's no point saying that you'll get that help. It's a never ending process then.
Good to know. This was good news and sad news, both.
Yeah,
But
I'll be-
mostly hopeful. Thank you so much, Vrinda. Such good information for Shweta's Talkies and the audience.
Thank you for having me here. Thank you so much.